Chapter 11, Capacity and Legality, presented by Kelly Herzik. We have already reviewed the major elements of a contract: offer, acceptance, mutuality, and consideration. We're now going to examine the next two elements of a contract: capacity and legality. To be enforced, contracts must have both capacity and legality. Capacity deals with the ability to enter into a contract, and there are certain classes of persons who can lack capacity. Minors, mentally incapacitated persons, and intoxicated persons. Legality deals with whether the contract has a lawful purpose, and there are some major categories of contracts that lack legality. There are contracts that violate state or federal statutes, and agreements that violate public policy. We'll finish up with the effect of illegal agreements on legality. We will begin with capacity. Capacity requires that you know you're entering into a contract and you have the ability to understand the contract's terms and conditions. Basically, capacity is the legal ability to enter into a binding contract. Capacity is required for every legally binding contract, and without capacity, contracts fail. A person with legal capacity to enter into a contract is one that has the ability to understand both the rights and the obligations of a contract, and presumably will be able to understand how to comply with the contract's duties and terms. You have to understand that you're entering into a contract, and you have to understand how you're going to comply with it. In contrast, one without legal capacity lacks the ability to understand the rights and obligations of a contract. Sometimes they don't know that they're entering into a contract, and sometimes they just don't understand how to perform it. But you have to be able to do both: understand the terms and conditions of the contract and be able to perform it. Incapacity can be due to a physical issue, such as mental deficiency or temporary intoxication, and sometimes it's by operation of law, such as the protection of minors. Courts will protect certain categories of persons because even though they may understand they are entering into a contract, they lack the ability to fully understand the duties and requirements of a contract. We will begin with the first large group of people who may lack capacity, and that is minors. Minors generally lack contractual capacity under the law, and if they do enter into a contract is voidable by them. Remember, we discussed the difference between voidable and void contracts. Void means the contract doesn't exist. Voidable means at their discretion they can rescind the contract and return the consideration. In most states, including Kansas, the legal age of majority is 18. In Kansas, for married minors, the age of majority is 16. In a few states, legal majority is 19, and one state, Mississippi, it's the only state in the nation, the legal age of majority is 21. In most states, if a minor is emancipated, they will have full legal capacity. In Kansas, to become emancipated, a minor must be at least 14, not living with their parents, be managing their own financial affairs, and have a legal source of income. The judge has the discretion to emancipate the minor if it's in the minor's best interest. That's the standard in Kansas for pretty much every family law issue with kids: best interest of the child. Emancipation occurs when a minor's parents or legal guardians give up their legal right to control the minor, and this is by court order in pretty much every state, including Kansas. In most states, if a minor marries, they are also considered legally emancipated. As I mentioned, married minors, the legal age of majority is 16 in Kansas. Disaffirmance of contract. Because any contract entered into by a minor are voidable, they can disaffirm the contract at any time while still a minor, or after reaching the age of majority, a minor has a reasonable amount of time to disaffirm or avoid a contract. They have to basically either accept or reject a contract they made as a minor in a reasonable amount of time under the circumstances. And a court will decide what is reasonable under the circumstances if the parties can't. To avoid a contract, a minor only has to manifest an intent to rescind, to disaffirm the contract either through words or actions. There's no magic to this. It has to do with the conduct of the minor. A minor must rescind the whole contract. They can't pick and choose terms they want to avoid and those they might want to keep. They literally have to take the entire contract or no contract. It varies state by state, but the general rule is that if a minor wants to rescind the contract, he or she needs to notify the other party of their intent to rescind the contract and return consideration given under the contract that the minor still has, regardless of the consideration's condition. This means that, for example, if a minor buys a car, the car can be returned with dings and scratches, some damage. It doesn't really matter. If the consideration has been damaged or destroyed, the other contracting party usually has no recourse against the minor. In some states, if the minor avoids a contract, the minor must put the other contracting party back in the same position as if the contract was not made. That's different in Kansas. In Kansas, the scope of when a minor is bound by contract is actually controlled by statute. It's Kansas Statutes Annotated 38-102. Under 38-102, a minor is bound not only by contracts for necessaries like food and housing and lodging, but also by the minor's other contract, unless the minor disaffirms them within a reasonable time after the minor attains majority, and they have to restore to the other party all money or property received by the minor. And they have to restore it based on what they have at the time they attain majority. That means whatever condition the property is in, whatever the minor has at the times they attain majority, that's what they have to return. In states where the minor has to put the other party back into the same position, that's known as restitution. But in Kansas, the duty of restitution doesn't exist for minors. There are some exceptions to the rule that minors can avoid their contracts. And there are a lot of them actually. And most of them are grounded in public policy reasons. Here are the exceptions that are the major exceptions recognized by law: life and health insurance contracts, psychological counseling, bonds and stock purchases, bank accounts, educational loans, child support contracts, marriage contracts, and armed force enlistment contracts. These are contracts that minors generally cannot avoid. But what about when the minor misrepresents his or her age when trying to enter into a contract? If a minor misrepresents their age, the majority rule is this does not affect the minor's right to rescind the contract. Even if they lie about their age, they can still avoid the contract under the majority rule. However, the minority rule is that if a minor misrepresents their age, but they look of age, if the other contracting party reasonably relies on that misrepresentation in good faith, the minor cannot rescind. Kansas is actually in the minority, which is surprising because we are usually in the majority on contract rules. In Kansas, this is actually governed by statute. It's Kansas Statutes Annotated 38-103. If a minor misrepresents his or her age, and the other party had good reason to believe the minor had the ability to contract, or from the minor having engaged in business as an adult, and the other party has good reason to believe the minor capable of contracting, then in Kansas, the minor cannot avoid the contract. Some states have a middle ground. They allow the minor to rescind, but restore the other party to the same position as before the contract, or they allow rescission, but also allow the other party to sue in tort for misrepresentation. Remember, in business situations, it's usually the company that bears the burden of determining the age of its customers. Businesses face criminal strict liability violations for sales to minors of alcohol and cigarettes. You remember this from our criminal law section. This is why stores that sell alcohol and cigarettes have protocols for identification checks to identify minors so they don't sell them cigarettes or alcohol. What about the liability of minors for necessities? In some states, including Kansas, minors have liability for contracts for necessities like food, clothing, medical care, and housing. In Kansas, minors cannot avoid contracts for necessities due to Kansas statute annotated 38-102. In some states, minors can usually avoid these contracts but will owe the other contracting party the fair value of the necessary item or service. In Kansas, that's not the case. Minors cannot avoid these contracts. Minors can ratify contracts that they made as minors once they reach adulthood. After a minor reaches the age of majority, he or she can ratify, which is called legally affirm, contracts entered into while they were a minor. Once the contract is ratified, that means the minor accepts the contract is no longer voidable and is generally enforceable. A minor can expressly ratify a contract by stating an intent to be bound orally or in writing to the other contracting party. A minor can also impliedly ratify a contract by taking some action consistent with ratification, like continuing to make payments on a contract. When can a parent be liable for the acts of their minor children? The general rule is that parents are not liable for the contracts entered into by their minor children unless they co-sign the contract and agree to be bound by it. Most businesses will not sell major items like a car solely to a minor because the minor can avoid the contract, return the car even if it has damage, and get a full refund. Therefore, they require a parent to co-sign on the sale and the loan. Parents do generally have a duty to provide necessities to their children, and in some states, if they fail to do so and the minor enters into a contract for a necessity, the parents can be liable for the reasonable value of the necessity. Generally, parents aren't liable for the torts of their minor children unless they fail to supervise the child and the child causes harm. In Kansas, parents are liable for the willful or malicious acts of minor children, with a cap of $5,000 plus court costs on the damages. If there's parental neglect, if there's failure to supervise, there is no cap on the damages and the parents can be liable for everything that the minor child does. Parents in Kansas can also be liable for damages in negligence actions for allowing children under 16 to drive, and for minors who shoplift or damage property with a general cap of $50 to $500. Now we're going to discuss mentally incapacitated persons and their ability to enter into contracts. Persons suffering from mental illness or a mental deficiency may have full, limited, or no legal capacity to enter into a binding contract. It really depends on their understanding of the contract and its terms, conditions, and duties. The key is whether the person can understand the nature of the contract and the obligations imposed by the contract. If they can, even though the person might have a mental deficiency, they can fully enter into a binding contract that is not voidable. If they can understand it, they can bind themselves. However, if a person's mental deficiency is such that they do not understand the nature of the contract or its obligations, the contract is still voidable. Once the person no longer suffers from any mental deficiency, he or she has a reasonable time within which to avoid or ratify any contract they made. As with minors, contracts for necessities can be enforced for the reasonable value of the necessity. Remember, if a person has been adjudicated as incompetent in a court and a guardian is appointed, they have no legal capacity and any contract entered into them is void. Only the guardian can enter into contracts for a person adjudicated incompetent. Let's talk about an example, and maybe that will help you understand the different levels of full, limited, or no legal capacity. If Barry has a mental deficiency because he thinks he's Napoleon, but he can understand a contract and what he needs to do to perform under it, he can enter into a binding contract. However, if Barry has no idea he is entering into a contract, but thinks he's giving an autograph when signing a contract, he has no contractual capacity. He can avoid any contract he makes in that situation. However, if Barry is adjudicated completely incompetent, by a court of law, then any contract he makes is void because only a guardian could enter into a contract on behalf of Barry. Next, we're going to discuss intoxicated persons and their ability to contract. Those adjudicated a habitual drunkard have no contractual capacity and their contracts are generally void. I've never seen this, but apparently it is a thing in the South. Most states, like Kansas, follow the Restatement Second of Contracts, which states that if a person is intoxicated, such that they cannot understand the nature of the contract and its terms, and the other contracting party has reason to know the level of the person's impairment, then the contract is voidable by the intoxicated person. Basically, you must be so drunk that you do not understand that you are entering into a contract, and the other contracting party knows how drunk you are and tries to take advantage of you. That's what that is in a nutshell. If the person's judgment is only impaired, but the person still understands the nature of the contract and its terms, the contract is binding. You may be in Vegas and get drunk and think it's a good idea to get married, but unless you think you're being sucked up into an alien spaceship instead of being married, you're married. Courts are generally unsympathetic to intoxicated persons unless the person was involuntarily intoxicated or drugged. Once the intoxication passes, in addition to a huge hangover, the person has a reasonable time to disaffirm or ratify the contract. However, courts are generally predisposed to find conduct that appears to ratify the contract as sufficient to do so, rendering the contract binding. It doesn't take much for a drunk person after they come out of the drunk to ratify a contract. If a person does avoid the contract, the parties are put back in the same position as if the contract did not happen. Again, necessity contracts will be enforced for the reasonable value of the necessities. We finished discussing capacity, so we will turn to the next element of a contract, legality. Legality deals with whether a contract is enforceable by law. Illegal purpose contracts are not a contract. They are a crime or criminal enterprise. An example is a contract to kill your spouse. These contracts are void. They're not a contract at all. Contracts that violate federal or state statutes are also void. Now, a contract can start legal but become illegal due to a new statute. If that is the case, it becomes discharged by law, such as an employment contract in a casino that becomes illegal to operate by a new statute. Then there are licensing requirements. Certain professions require a license to practice that profession. Doctors, lawyers, stockbrokers, real estate agents, plumbers, electricians, cosmetologists, and teachers are all examples of professions that require a license within a state to operate legally. If a license is required to practice a profession, a person must have a license to enter into a contract to perform services in that area. Generally, if the person does not have a license, any contract for services is void, particularly if the purpose of the license is to protect the public. For example, lawyers who don't have a license to practice law are committing the unauthorized practice of law. It's illegal in Kansas. Any contract they enter into for the provision of legal services is void, and they cannot keep any fees charged, plus they can be sued for damages. Next, we're going to talk about usury. Statutes prohibiting usury have been passed in virtually every state. Usury is the lending of money at an unlawful or an exorbitant rate of interest. Usury caps vary from state to state, but lending above the cap renders the contract void in some states. In other states, the principal can be collected, but no interest is allowed, while others allow the lender to recover the principal plus interest up to the legal maximum. Kansas is somewhere in the more of the last category. Kansas has several statutes that govern the legal interest rate allowable. What statute applies depends on the type of contract, such as a first mortgage or a payday loan, as to which statute actually covers and gives you the cap rate. The general usury provision in Kansas is 16-207, and it has a usury cap of 15%. There are other caps like in the Uniform Consumer Credit Code and in the Payday Loan Statute, but I think that what you need to know for testing purposes is that the provision in Kansas, the general usury rate is 15%. In Kansas, the penalty for usury is to forfeit all the interest and to have the amount of the interest contracted for in excess of the legal amount deducted from the principal and lawful interest due. So it doesn't actually void the loan in Kansas, but if you use a usurious rate, it's a pretty big penalty. There are exceptions to the general rule on usury, the most notable of which is corporate or agricultural lending. In many states, including Kansas, usury statutes only apply to consumer lending. That means that the loan has to be for personal, family, or household purposes. They don't apply to commercial lending, and that includes agricultural or farm loans. Another exception is small loans such as payday loans, but in many states, including Kansas, this type of lending is heavily regulated and has its own statutory interest cap. You really have to do some research in Kansas on what type of loan you have to find out what the actual usury cap is. Next, we'll discuss gambling and Sabbath laws. Most states regulate gambling. Gambling is an agreement to pay consideration, money placed on bets, for the chance to obtain money. In most states, gambling is illegal, though many states, including Kansas, allow casino gambling and state lotteries. Casinos on Native American lands are also exceptions to state gambling laws. Sabbath laws prohibit certain activities or sales on Sunday. These are also known as BLAW laws. Most of these Sabbath laws prohibit or restrict the sale of alcohol on Sundays. That's, I think, the biggest example of a Sabbath law. Businesses need to make sure Sabbath laws do not restrict their businesses in a particular state. Kansas has some of the strictest liquor laws in the country and even has its own Wikipedia page. The current Kansas Liquor Control Act now, though, does allow cities and counties to permit Sunday liquor sales. That doesn't mean they are allowed in Kansas. That means that the county or the city, if they so choose, can sell liquor on Sundays. Next, we'll discuss agreements that violate public policy. Unlike some agreements which are precluded by statute, some agreements are not per se illegal due to a violation of a statute, but are unenforceable because they violate public policy. The focus is on both the government's concern for its citizens and the beliefs of the communities regarding the proper scope of business transactions. The key is society's best interest. You might remember that we talked a little bit about this in Chapter 2 in Business Ethics. It's about community standards and what a community expects of a fair business in that community. There are contracts in restraint of trade. Contracts that restrain or restrict trade are bad for consumers and businesses and thus violate public policy. These are generally known as anti-competitive agreements. There is a main exception that you need to know for testing purposes, and these allow some types of contracts that restrain trade. They are known as covenants not to compete or restrictive covenants. This type of contract restricts a party for competing against the other party in business for a set period of time within a specific geographic area. We're going to discuss covenants not to compete in some detail because they are becoming more common in the business world. Covenants not to compete are generally enforceable and fall into two basic types: non-competition in the sale of an ongoing business and non-competition in employment. We're going to talk about the sale of an ongoing business first. When a business is being sold, covenants not to compete are common. They restrict a party from opening a new business to compete with the business they're selling. As long as they are geographically limited to reasonably protect the existing business and are only for a set term, they're generally enforceable. That means that you can't open up a pizza joint for 2 years within Wichita if you just sold your Wichita pizza joint. In the employment setting, courts have generally found that covenants not to compete are enforceable if they are reasonable and necessary to protect a legitimate business interest of the employer. This includes customer relationships or trade secrets. Client lists can also be protected depending on the business and how dependent it is on a client list. In the employment contracts arena, they have to be narrowly tailored in both time and geographic restraints because they restrict people from working. Kansas has upheld time restrictions of up to 2 years, though each one is evaluated based on the particular facts and circumstances. Geographic restrictions cannot be overbroad. But what about a plumber or welder that receives on-the-job training? Are covenants not to compete based on job training enforceable based on a legitimate business interest? Kansas courts generally ask these 4 questions in evaluating a covenant not to compete that is part of an otherwise valid employment contract. Whether the covenant protects a legitimate interest of the employer, whether the covenant creates an undue burden on the employee, whether the covenant is injurious to the public welfare, and whether the time and geographical limitations are reasonable. While Kansas courts generally enforce these agreements, they can be challenged, particularly where there is not really a legitimate employer interest in prohibiting an employee from working for a competitor because the employee has only general skills acquired while working for the employer. General skills learned during employment can be transferred and cannot be protected by a covenant not to compete because it would be an undue burden on the employee. So remember the question that we asked on the previous slide. Can on-the-job training support a covenant not to compete? The answer is no. On-the-job training is usually not enough of a legitimate business interest to enforce a covenant not to compete. So an employee can take those skills to the next employer even if they receive training at their current employer. Next, we'll talk about unconscionable contracts. Usually when courts evaluate contracts, they assume the parties do their due diligence and enter into contracts because they want to as responsible adults. However, there are contracts that are so one-sided, so unfair, or based on coercion, duress, or fraud that they simply should not be enforced under equitable principles. It's hard to tell exactly what an unconscionable contract is because it's a sliding scale. It's a I'll know it when I see it type of standard. These contracts are unconscionable contracts. They are so unfair they are void of conscience. They are also void contracts. Unconscionable contracts are those in which one party has so much more bargaining power than the other party that the dominant party dictates the contract terms and the other party has no real free will. What does that sound like? Lack of mutual assent. It's basically a take it or leave it contract with no ability to bargain. It's an adhesion contract. There are 2 main types of unconscionable contracts: procedural and substantive unconscionable contracts. Procedural unconscionability refers to the process of making the contract itself. These refer to the conditions that would interfere with the party's ability to understand the contract terms, like small print, rushed signings without the ability to read the terms, or excessive legal language designed to confuse a party. Anything that would procedurally impede a person's ability to understand the contract they're signing, that is procedural unconscionability. As I mentioned before, they're often adhesion contracts. These are the take it or leave it contracts. You don't get to negotiate. This is what you get. They are usually enforceable until they become so unfair, so one-sided that courts deem them unenforceable due to unconscionability. Remember, it's a sliding scale. They're enforceable until they aren't. It's just how far down the road of unfairness does the court think a party can go without it being unconscionable. Substantive unconscionability refers to overly harsh or unjust substantive terms in a contract itself. These are contracts generally where one party has all or virtually all the advantages and legal remedies, and the other party usually has most of the burdens and little legal recourse. A lot of times, exculpatory clauses in contracts that release one party from liability regardless of fault or degree of injury are considered unconscionable. The general rule is that these tend to be against public policy, particularly in consumer contracts. They're highly disfavored and are usually ruled unenforceable by courts unless the business or activity is not important to a public interest. A public interest is something like housing, safety in property. There are some examples of exculpatory contracts and disclaimers that can be enforceable, mostly with inherently dangerous activities like skydiving, amusement parks, skiing facilities, and even health clubs. These are the kind of exculpatory contracts that are enforceable because they are a type of participate or ride at your own risk activities. Next, we'll discuss the effect of illegal agreements. Contracts with an illegal purpose are usually ruled to be void. They're usually considered void because both parties are equally at fault for entering into an illegal contract. This is called in parte delicto, in equal fault in Latin. There are exceptions. The first is when a member of a protected class is involved in a contract that contradicts a statute designed to protect the specific class. A good example of this is on page 231 of your textbook about the truck driver. When a truck driver accidentally drives more hours than allowed under a statute, his employer cannot refuse to pay the driver due to the overtime being illegal, and the driver could sue the employer for the overtime. I think that's the best example that there is of that. The second exception is justifiable ignorance of the facts. One party does not know that a portion of the contract is illegal. Ignorance of the law is usually no excuse, no defense to a contract, but not knowing that the other party plans to use illegal means to fulfill the contract is a defense to a contract. The last exception to voiding of illegal agreements is withdrawal from the illegal contract before the illegality occurs and the party has not participated in the illegality. That just means that if the court can enforce a legal portion of the contract because you withdrew from the illegal portion before it started, you have a chance perhaps of getting paid. The last area in this chapter that we're going to discuss are severable contracts. Severable contracts can contain multiple parts that can be performed separately. Each part has separate consideration and is like several contracts in one contract. A severability clause in a contract states that its terms are independent of one another so that the rest of the contract will remain in force should a court decide that one or more of its provisions is void or unenforceable. Courts will review each part of the contract for legality, and courts can strike the unenforceable clause and still enforce the legal clauses. Think about what I just said in the last slide. Suppose that you enter into a contract that has an illegal section. You realize that and you withdraw from the contract and don't participate in the illegality, and you withdraw before the illegality started. You have a chance to ask the court to sever the illegal portions and enforce the portions that you completed so that you can get paid. However, the remaining legal portions must still represent the main purpose of the original contract. An indivisible contract is one that requires complete performance by both parties. If the contract is indivisible, courts can only declare the entire contract unenforceable or enforceable. It's an all or nothing provision. It's just a contract that isn't capable of being broken up into parts. Like a contract that says, I'm going to sing the national anthem. That's the only portion of the contract. There's no way to break that up into parts. It's either enforceable or it's not. This is the end of Chapter 11.